Hi, welcome to my screencast for Special Ed Law, EDU 518. This is my Module 1 presentation, and the purpose of this video is to give you a historical look at a number of laws and educational practices that have affected students with disabilities. Those include IDEA, Section 504 of the Rehabilitation Act, FERPA, the Every Student Succeeds Act. We'll compare that with Nickleby and several others. So let's go ahead and begin. Really, it all kind of dates back to 1954. With Brown versus Board of Education of Topeka, Kansas, I don't think that most of my colleagues even would think when you're talking about special ed that you would associate such a historical Supreme Court case that most people I think associate with civil rights to special ed. But what it did is it opened up the door to allow for the federal government to help get involved with education and to make decisions that maybe supersede what the states want to do. So in 1954, Linda Brown, a young student, wanted to attend a school of her choice. It went all the way to the Supreme Court after it had been defeated 5 times in the lower courts. And in the end, with a 9-0 ruling, this case overturned the 1896 case of Plessy versus Ferguson, which very famously ruled that separate facilities was constitutional. And so what this did was it declared state laws required separate schools for blacks and whites to be unconstitutional. And again, as you're going to see as we go through this, you're going to see how that opens up the door for special ed. Chief Justice Earl Warren at the time gave, I think, one of the more memorable quotes from his time on the bench when he said that education is perhaps the most important function of the state and local governments. It is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity is a right that must be made available to all on equal terms. Does segregation of children in schools solely on the basis of race deprive children of the minority group of equal educational opportunities? We believe that it does. And while the end of that is talking specifically to race and civil rights, clearly special ed is also a civil rights issue. And so what Chief Justice Warren is saying that any student who's not given an equal opportunity to an education is being deprived of, equal citizenship, as the 14th Amendment notes, and we'll talk more about that in a bit. So I think it's very important to understand the words that even though, again, Brown versus Board of Education is talking specifically about Linda Brown and the other folks involved in that case, that it really does involve special education. Moving ahead to the year 1972, Mills versus Board of Education of the District of Columbia was another key integral case. This case was one of 2 important federal trial courts, the other being Pennsylvania Association of Retarded Children versus the Commonwealth of Pennsylvania. What it did, it helped lay the foundation that eventually led to the passage of Section 504 of the Rehabilitation Act of 1973, and Education for All Handicapped Children Act, which is now the IDEA, and both of which helped change the face of American education. Mills versus Board of Education of the District of Columbia, what that was prior to 1975 and the enactment of these laws, many schools did not offer special education for students with disabilities. As such, millions of students were denied appropriate services or excluded from public education entirely. Legislation that guarantees these certain rights, what that is, it is Section 504 of the Rehabilitation Act. And so individuals with disabilities, it says, it was the first U.S. federal civil rights protection for people with disabilities and the forerunner to the ADA. And it states, quote, no otherwise qualified individual with a disability in the United States, as defined in Section 705 of the title, shall solely by reason of his or her disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, or under any program or activity conducted by any executive agency. To continue on with Section 504, in addition, Section 504 can be valuable in providing rights to students for issues outside of the school day, such as any type of extracurricular activities. Could be like a chess or a drama club or something like that, sports, any type of after-school care programs that they may have, like a 21st century program or anything to that degree. For example, a volleyball coach simply cannot deny a student a fair tryout because they don't feel like that student who is dealing with some type of disability would be a hindrance upon their team. They have to give them equal opportunity. The law states that schools must identify students with disabilities, evaluate those students, and if the student is eligible, create a written accommodation plan, again, which we now know in the educational world as being a 504 plan for those students. I know specifically as an educator, I've had students who have had even handwriting conditions who have been given 504s because their handwriting due to a disability by which I do not know the name, but I do know that these students were given accommodations because their handwriting certainly could impact their scores were it left up to an individual who didn't want to try to take the time to work with those students, which I certainly did. But you can see where, there could be people who want to take off points because they can't read that student's handwriting. So they were allowed to have a scribe, or maybe they could type homework assignments or tests and those types of things where other students couldn't. Some of the other examples of accommodations for specific disabilities are here. I won't read them all, but even things like allergies. Of course, ADHD is something that we've really come to know a lot about in the past couple of decades. Eating disorders, drug and alcohol, substance issues, of course, learning disabilities, even visual and hearing impairments, and all kinds of other things. Examples of 504 general accommodations, they fall into basically four categories: environmental strategies, behavioral strategies, organizational strategies, and presentation strategies. So these are things that should be done to try to help accommodate the student. Examples of environmental strategies could be something like a change in the seating for the student. So if it's a student who has visual impairment issues, then they can sit closer to the board to where they can see. Example of behavioral strategies, any type of use of behavioral management techniques. And, that can be something as simple as allowing a student to get up every once in a while to walk around, or asking them to hand out paper to get them out of their desk. Or, there could be all kinds of different things, simple signs or motions to let the student know if they're acting in a behavior that's not proper for the classroom. Example of organizational strategies would be things like to ask the teacher to write out all assignments and to provide plans to students. 504 plans can also include having that done with other students. There's lots of ways in which you can help with organizational strategies. And then as far as presentation strategy, maybe record lessons so that students can view and listen to them again as needed. Moving forward, so in 1975, the Individuals with Disability Education Act, or I guess we're going to talk about that. Congress passed first in 1975 the Education for All Handicapped Children Act. And in 1990, the United States then reauthorized EHA and then changed it to IDEA. So it's been around since 75, but under the new name since 1990. And overall, the goal of IDEA is to provide children with disabilities the same opportunity for education as those students who do not have any type of disabilities. Individuals with disabilities, there are 6 components of IDEA which were laid out. The first one was the creation of IEPs. I think anybody in the education profession now should know what an IEP is, but an individual educational program. And that's a specific plan that you meet annually as a team to talk about what the best course of action is to make sure that student is being given an equal opportunity to an education. Typically, classroom teachers, there's going to be administrators, special ed teachers, anybody that they receive services with outside the school. There's going to be a lot of individuals who get to have input into the IEP, which by law is to be followed within the classroom. FAPE, the free and appropriate public education, is another aspect of that, and that really does a couple of things. Which one of those they provide at the public's expense under public supervision and direction without any charge. That's important. You can't say, okay, well, we'll give you the same education, but you're going to have to pay more money because we have to hire a one-on-one or something like that. You can't do that. It has to meet the standards of the state educational agency. It has to include an appropriate preschool, elementary, or secondary education in the state involved. And last thing, it has to these things have to be done in conformity with what other students are doing. That kind of blends into number 3, the least restrictive environment. When I was in school, not that long ago, I know a lot of students with learning disabilities who were pulled out of the classroom. Today, we try to practice keeping them in the classroom as much as possible. So the least restrictive environment is that which keeps them with their peers most of the time as appropriate. Another aspect of that, is you can see on the screen, is the appropriate evaluation, and that's just to make sure that children are placed in special education services through an evaluation process. And if the evaluation is not appropriately conducted or does not monitor the information really that's needed to determine the placement, then that is not appropriate. So the goal of IDEA's regulations for evaluation is to help minimize the number of misidentifications, to provide a variety of assessment tools and strategies, and to prohibit use of any single evaluation for students that they feel could have disabilities. Moving on, parent and teacher participation. A good family and professional partnership is really key for a student to receive the education necessary for success. Parents and teachers need to be really willing to work together and communicate to determine the best ways of working with and providing information for a student. So one part of IDEA is to make sure that there's that communication going back and forth between school and home and vice versa. And then the last part is any type of procedural safeguards. And really what I mean by that, making sure that there is proper access to educational records, that parents can come in and view that at any time, that there is prior written notice any time that there's a change to an IEP, making sure that for students who need translators that there's an understandable language, as they put it. Of course, protection of due process. And so there are a lot of different aspects of IDEA which they put into place, which were just much more, clear, and they wanted to make sure that they included things where violations were taking place throughout the country. They wanted to close those loopholes. Because IDEA also applies to K-12 schools, because it applies to K-12 schools, people sometimes mistakenly assume that with IDEA, the Rehabilitation Act, or the 504s, is kind of superfluous. But in fact, however, IDEA only protects a subset of children and youth who do have disabilities, those who satisfy its definition for, quote, child without a disability. And there are many young people with disabilities that do not meet that definition. So that's why it's really important to make sure we have both. So the Americans with Disabilities Act, or better known as ADA, was something that was signed into law in July of 1990 by President George H.W. Bush. And the ADA is one of America's most comprehensive pieces of civil rights legislation. And it prohibits discrimination, and it guarantees people with disabilities have the same opportunities as everyone else to participate in the, quote, mainstream of American life. It was later on amended in 2008. And what it does is it makes it unlawful to discriminate against students because of their disabilities. It defines the term disability, and it also includes physical or mental disabilities as well as substance abuse. It explains what accommodations should be made for individuals with disabilities and what performance functions are reasonable. It also outlines the legal consequences that can be issued when violations of the law do occur, and it sets forth guidelines regarding confidentiality. Regarding confidentiality, FERPA, of course, is the first thing you think of as an educator when it comes to confidentiality, and it is federal legislation that protects the